Mr. Cobb's coming on Zoom. Hello, Mr. Cobb.
Hi, Judge. How are you?
Doing well. How are you?
Good.
Mr. Cobb, what case did you have on the docket?
Godwin.
Okay.
Daniel, I believe.
Okay. And Mr. Godwin wasn't incarcerated, right?
He's not incarcerated, he's in the Florida State Hospital.
Gotcha. Okay, yes, that was the,
He's in Chattanooga, I thought, Judge, at the state hospital.
right, and I had a prior report for him that was October 10th. Did the court enter an order in relation to that, or is that still outstanding?
Are you asking me, Judge?
Yeah,
or-
in either one of y'all.
No, sir, I haven't seen an order. I know that, I was recently appointed and I know what the charges are. I spoke to Mr. Godwin via telephone at the hospital, but I haven't seen an order determining competency
Okay.
so far.
So we need to set Mr. Godwin's case for a competency hearing?
Judge, I think that's the posture that the case is in right now, yes, sir.
Okay, to the state, you okay with that? This is Godwin, Daniel Ray Godwin.
Yes, Your Honor.
Whose case is Daniel Ray Godwin. Was on the 9 o'clock docket under Mr. Cobb's name. Number 3 on the 9 o'clock docket. And it just said a hearing, so that was why I looked at the competency report and thought that's what I was hearing.
Hold on, Your Honor.
Judge, was it scheduled today for a hearing on the competency report from October?
It just says hearing.
Uh,
You've got the case number, Mr. Gomez?
Which one are we working?
It's
through?
20 CF 1515.
This is ASA Leah Glisson's. Well, let me try to look through. Okay. Can the court refresh what we were just talking about? Because I, to be quite honest, was looking at another case that I was prepping for.
The last thing that I saw that I thought we may be having a hearing on was the October 10th, 2024 continued commitment as incompetent to proceed, where the doctor gave the recommendation or the opinion that the defendant was incompetent to proceed. And then on page 3, it was talking about that Mr. Godwin was not adhering to the medications.
Okay. I mean, based on briefly reviewing that report, I think as long as he's remaining in the Florida State Hospital, then we're not going to, I think, object to continuing the involuntary or the commitment to the Florida State Hospital. I think if it's this court's feeling that we should not have him in the Florida State Hospital, then I would definitely want Ms. Glisson to be able to be present and to be heard, Your Honor.
Okay. It's my just overall belief that once somebody is sent to the Florida State Hospital, they appear in front of the court about 6 months after that initial determination, and then they're supposed to appear in front of the court annually for the court to make the determination. Whether the appearance has to be physically.
Okay, I'm sorry. The reason why we set this, I actually sent an email on October 14th, which is the date that the clerk's minutes were entered into. Mr. Rhodes had previously withdrawn because he had a conflict. We asked originally to set this in January, but Judge Brown ended up setting this for 11/21 to make sure that he had another attorney.
Good.
That was the purpose of this hearing today, was to make sure, I guess, that Mr. Cobb got appointed.
Okay, so Mr. Cobb, you represent Mr. Godwin. If you will, do you want me to set it for a status conference? Do we want a hearing for the court to determine if he remains incompetent to proceed? If it is going to be the latter of those two, I don't know if the Florida State Hospital does Zoom. I've never seen them do that. But if we are going to, the court's going to make some determination, I want to make sure Mr. Godwin is present, either via Zoom or live, okay?
Yes, sir. We just need it for a hearing for the court to determine his continued status of his competency.
Okay.
That's what it's it for.
Why don't we set it for December 12th at 9 o'clock, okay? And Mr. Cobb, I'm putting the burden on you to figure out how your client's here. If there's any way that Florida State Hospital will let him appear via Zoom, that would be easier. But if he needs to be transported, you'll need to get me an order, okay?
Yes, sir, I will on that.
Okay. Thank you, sir.
You're welcome. Have a good day, everybody.
Thank you. You too. Okay, then we're on the 2:30 docket. And it appears everyone is represented. Is Mr. Ufferman's not present? I don't see him.
Judge, and I believe for Stoffel, Ms. Basso had exchanged some emails with the court and Mr. Ufferman, and I believe at the court's suggestion, they thought this would be more appropriately heard in front of Judge Stone, since Judge Stone is going to be the one that's going to be resolving the case. So everyone had agreed to continue it.
Okay.
He's here, so we didn't know that it was.
Mr. Ufferman's here?
Mr.
Why don't-
Stoffel is here.
I'm sorry, Mr. Stoffel's here. If you want to bring him out.
Okay, Dan was Stoffel.
Everything is in file. 14 CF, 18 CF.
No, sir.
Nothing.
Nothing since October 16th when we filed a notice.
Okay.
Here we are.
This is 14 CF 1876. Hello, Mr. Stoffel.
How you doing, sir?
Good, how are you?
All right.
Mr. Stoffel,
Yes,
as far as the clerk's filings, there isn't anything that's filed after the setting of this hearing. Ms. Barrickman, but if you'll refresh the court's memory.
Yes, Judge. I believe that Mr. Ufferman and Ms. Basso were in discussions with your JA. At your Honor's recommendation, they were going to put it on Judge Stone's docket, so he'll be the one to hear the underlying case. So they were just going to ask for a date sometime in January.
Okay, so it's a new case?
No, Judge, this is a 3850.
It's a 3.850?
Mm-hmm.
Okay. And from what you understand, Mr. Ufferman's not going to be prepared to argue that before the end of the calendar year?
Yes, Judge, that was my understanding from speaking with Ms. Basso. So they were just
Okay.
asking for a miscellaneous date in front of Judge Stone, and I believe they asked Ms. Donna to take it off this docket, but I guess that didn't quite happen.
I didn't see it off. You don't have anything scheduling it? Mr. Stoffel, my concern, even though it's in at 3.850, but I'm scared if it falls off the radar.
It
I don't
sure
know when
seems
it'll
like
come
it,
back
Your
up.
Honor. I've been waiting in county for 2 years now, over 2 years.
Yes, sir. Do
I
we
would love to have a
any
hearing.
miscellaneous criminal dates for Judge Stone?
In January, no, sir.
Okay, what about February?
The first miscellaneous that he has is February 13th.
Okay. Mr. Stoffel, I'm going to put it on February 13th at 9 o'clock in front of Judge Stone. But your attorney should stay in touch with you. Tell him to do whatever he can. I wish that everybody would be up to speed where I could hear it in December.
Sir, if you're willing to hear in December, I'm willing to present it myself if I have to.
Yeah.
It's not that hard of an argument.
Well, you've got counsel, so they're your mouthpiece. But you tell Mr. Ufferman, I've got 4 different dates in December. I'm ready to hear it whenever the parties are ready, okay?
Your Honor,
Yes,
may I
sir.
request one of those dates and I'll give him a call today?
No, he's got to do it. Again, he's your mouthpiece to the court, okay?
I haven't spoken to him in over almost a year now. It's hard to get in contact with him, Your Honor.
Okay.
I know he's a
Then-
busy man, he travels a lot.
Then I will communicate with Mr. Ufferman and
If I
then
could have it
CC the
before-
state.
Have it this year, I would love it, Your Honor.
Let me put it down and make sure that I do that. And it's Ms. Basso is the state?
That's correct, Judge.
My attorney's office did inform me that they were waiting on a response from the state, but in the past year, they've only contacted them 2 or 3 times and nothing came of it.
Okay.
But again, my conversation with them is very limited.
Okay, I'm going to keep it set for the February date, but if I don't get some good input from both of the attorneys, then I'm going to set it for a status conference in front of me in the next few weeks, okay?
Yes, Your
Say-
Honor, if I can show up in person or video, either one, I'll be happy to oblige.
Okay.
Please.
Yes, sir. Okay, thank you, sir.
Thank you, Your Honor.
You're welcome. Okay. To the PD, which case do you want to take next?
We do,
Scott, I'm gonna stipulate to this one.
okay.
Mr. Kleins?
Your Honor, this is Miss Mandolini. She's before the court on the motion. Mr. Gomez has indicated the state's going to stipulate to this motion.
That's correct, Your Honor.
Okay, so we're converting them to signature bonds?
All of her bonds would be converted to signature bonds, Your Honor. I think technically the court would have to set the bonds on 22, all the 22 CF cases. I don't think that there's ever been a bond set on those. So we would just ask the court set $2,000 signature bonds on each one of those 22 CF cases, and then reduce the previously set cash professional bond at 24 CF, 2,100 to signature bonds.
Okay. Are there multiple counts in any of the 22 cases? Are they, it's just 2,000 signature for each count?
No, just, 2,000 signature for each count, Your Honor. There's
Okay.
4 counts in 22 CF 93, 1 count in 22 CF 94, 2 counts in 22 CF 277, 1 count in 22 CF 395.
So, Ms. Mandolini, I'm converting your existing bonds into signature bonds, and on all of your 22 CF cases, your bonds are set at $2,000 per count, and all of those are signature bonds. So you'll be able to sign out of jail without posting any money. If you fail to show up when you're supposed to, then you'll owe that amount of money, okay?
Okay, thank you.
So when will I see Ms. Mandolini next?
All all of these cases should be on the January 13th docket. If they're not already on that docket, I would ask the court to put them all on that docket.
Okay. Ms. Mandolini, it'll be Judge Stone, but you'll see him on January 13th, okay? Thank you.
Thank you.
Give me a call when you get out, okay?
I will, thank you.
Xavier Martinez. I have Anthony Barnett from the 9 o'clock docket.
Your Honor, Mr. Barnett is approaching. We do have an offer from the state of 29.55 months in the department. I need to talk with some things with Mr. Barnett to go over them. This offer would not result in his immediate release, so I would ask the court to put Mr. Barnett's case on the December 15th docket. I do expect there's going to be a plea on that date.
Okay. Mr. Barnett, I'll see you on December 16th. Okay. Thank you.
I see you.
James McQuade. He was on the 100 docket. Is Mr. Klein?
Your Honor, this is Mr. McQuade, and I do appreciate the court and the state letting us argue this motion today. I do need to make a correction. In the motion on Mr. McQuade, I put that he stated he had no prior failures to appear. I looked at his CCIS. There was an FTA on a county court case, I believe from 2021. And to his credit, when I asked him about it, he said, yeah, I forgot about that. But it was a misdemeanor. But other than that, the motion should be accurate.
Okay, hold on 1 second. Let me find it. You emailed it to me and I printed it off.
I can, does the court want a paper copy?
Got it. No, sir, I've got it and I've got it highlighted. Yes,
Okay.
sir.
So, Your Honor, we are essentially asking the court to reinstate a bond in 24 CF 2388. What happened was Mr. McQuade was arrested on that case. He posted cash or professional bonds. He was released from jail. He then picked up 24 CF 2440, and bond was revoked in the 2388 case. And then there was cash or professional bonds set on that 2440 case. Mr. McQuade is requesting the court to reinstate the bond in the 2388 case, reduce the bonds already set in the 2440 case to signature bonds. He has lived in this area for about 29 years. To his credit, it's not common that I see somebody working for the same company for 11 years. It does appear that he has a steady job. He's a local, for lack of a better way of saying it. He would live at 615 Colonial Drive with his girlfriend. Is there anything else you want? That's right. I did look at his pretrial paperwork. He's already been ordered to report in person once a week for pretrial services, and to have no contact with the alleged victim in the 2440 case. He's not asking the court to modify that, and he was just advising me that he wanted you to know that he wasn't going to go anywhere near Mr., I think it's Way, yes.
Good. Thank you, Mr. McQuade. Thanks for that. To the state.
Yes, Your Honor, I think in this situation, the state's going to respectfully request that the motion to reinstate bond in 24 CF 2388 be denied, and to deny the motion to reduce the previously set bonds. In the 24 CF 2388 case, Mr. McQuade was booked into the Okaloosa County Jail on October 12, 2024 at 7:37 a.m. He posted those cash professional bonds on October 17th at 8:41 a.m. He was then rebooked back in on this new charge on 10/17 at, I think, 10:43 p.m. So didn't even really go a little over 12 hours before getting a new law violation in this case. I think that not only shows his lack of willingness to comply with the laws of this state, Your Honor, but also doesn't respect the fact that he was out on bond in 2388 and goes less than a day before committing a new law or an alleged new law violation. I also think it's a little bit alarming and concerning for the state that the new law violation is a felony battery in which he allegedly approached an individual in a store, ripped his necklace off, and then committed a felony battery. So, Your Honor, respectfully, we feel as though for the safety of the public, but also it's very clear that Mr. McQuade is not willing to follow the laws. We would respectfully request that this motion to reinstate bond be denied and that the motion to reduce the previously set bonds also be denied, Your Honor.
Thank you.
Your Honor,
Mr. Klein, finally?
Mr. McQuade wants the court to know that the alleged victim in the 2440 case, he has reason to believe that that alleged victim was responsible for breaking into Mr. McQuade's car. I can't speak to any of that. I don't have discovery. I can tell the court, when I found that prior FTA, I did note that Mr. McQuade went a substantial period of time without having any involvement in the criminal system. Off the top of my head, in 2014, there was some kind of a criminal mischief case, and the next time he had anything in CCIS was 2021. So, I mean, I got to play the hand I'm dealt, as the court likes to say. I can't do much about the timing of what happened here with Mr. McQuade, but he's consistently claimed that this individual was responsible for breaking into his car.
Okay. Mr. McQuade, and I don't say this to prompt anything from you because I don't want you to say anything factually about your case because everything's being recorded. It can be used against you and the state sitting to your right. But I just want you to understand what my thoughts are. You know, I can only look at the facts that are in the sworn arrest affidavit. And in there, the things that stuck out to me was this occurred, all of these are allegations, allegedly occurred in Winn-Dixie. And then when I jumped down to post-Miranda, you allegedly stated that you received a call from a friend who stated that the victim was in the store. Then you went to Winn-Dixie to confront the victim about the alleged vehicle burglary, which had not previously been reported to law enforcement. And then it talks about what actually happened, or at least allegedly happened. I do have concerns about self-help, not going to law enforcement, taking the law into your own hands from these allegations. So respectfully, your motion to reinstate bond and reduce the previous bonds are denied. So will Mr. McQuade be back on January 13th?
He will be back on January 13th. I did advise Mr. McQuade I would try to see if we could get this resolved in the month of December. So hopefully we can get something put together and have Mr. McQuade back before the court before Christmas.
So Mr. McQuade, if the state offers you something that you want to accept before the end of this year, Mr. Kleins can set it for a hearing. Thank you, sir.
Right. I'll see if I can get an offer. I'll talk about it.
Now I have Xavier Martinez back on the Tuesday.
Thank you. Hello, Mr. Martinez. Good afternoon.
Your Honor, this is Mr. Xavier Martinez. He's here on a motion to reduce and modify bond. The bond modification is talked about in paragraph 4. This is his sister. The independent charges that I'm talking about in that paragraph, I believe she picked up a resisting an officer without violence or disorderly conduct. That's why I said it was independent of whatever he's accused of doing, because it was based on her conduct during the traffic stop. But she is his sister-in-law. I have not had a chance to talk with her personally yet, but based on conversations I've had with Mr. Martinez, this was a car that belonged to her. The gun was found kind of where you would expect to find a gun if somebody was having it in a car between the center console and the driver's seat. And I believe that she's going to have a concealed carry permit, but I wouldn't testify to that at this point.
Yes, sir.
But that's what we're asking for the modification, so he can have no violent contact with Ms. Gwynn. As far as the monetary amounts of the bond here, he's requesting, I do have to make an oral modification. He cannot afford a $2,000 cash or professional bond, so he does want to ask the court to reduce that $25,000 bond to $1,000 cash or professional. Money's tight, especially this time of year. That's why, even though in writing it's 2,000, talking to him back there, he just couldn't even afford that. But I did, and I have stressed to him that based on the allegations here, that I think it's just asking too much to ask for total signature bonds across the board. I don't even know if he could post this $1,000 bond if the court reduced it. He recently moved here from New York. His kids did precede him down here, and they're already enrolled in school. I could definitely see a bondsman having issues with a recent move to the area, and I'm willing to take the bond, but that's something he'd have to deal with. He would live at 1807 Whispering Oaks Lane in Fort Walton Beach. He is a professional chef and works as a barber. He states he has no prior failures to appear. There is a potential issue of whether or not he's even a convicted felon. I know Mr. Gomez is trying to track that down, but we are simply asking the court to consider reducing the bonds. The one for the DUI and the one for the possession of the firearm, we're asking the court to reduce those to signature bonds, but we're asking the court to reduce the $25,000 cash or professional on the fleeing charge to $1,000 cash or professional.
Thank you. To the state.
Yes, Your Honor. The state's going to respectfully request this motion to reduce and modify. I'm okay with the modification of the bond for Mrs. Gwynn to no violent contact. I do agree with Mr. Klein's statements on that. However, the state's going to respectfully request that the bonds remain the same or the same amount, particularly on the possession of a weapon by a convicted felon. That's the one that the state is particularly concerned about. With respect to what Mr. Klein had said about the status as of a convicted felon or not, the main reason why I'm not for sure on that is because generally speaking, when we intake a case, we get a criminal history run through NCIC or anything like that. I have reason to believe that the NCICs that I'm looking at in this case are incorrect because I think the name altogether is incorrect, so I can't really speak as to his prior record or anything of that nature. I will say that the circumstances around the fleeing and attempting to elude are a little bit concerning for the state. He did drive away at a very fast speed and to the point where a felony takedown had to have been conducted on the vehicle to get them to stop. So there are, I think that in and of itself brings about fleeing concerns, the fact that he's not necessarily from the area, he just recently moved down. We do feel as though the $10,000 for count one is reasonable, as well as the $25,000 for the count of possession of a weapon by a convicted felon is reasonable. So respectfully, Your Honor, we would request that these bond amounts stay or remain the same that they are, Your Honor. And I would like to point out, there was a breath, and it was, .176, .186. So not only was he fleeing and attempting to elude, but, I think it's somewhat obvious that he was also intoxicated at that time, Your Honor. So there's concern for the safety of the public in that regard, and so that's why we're requesting these bonds remain the same.
Thank you. Mr. Kleins, finally?
Mr. Martinez just wanted the court to be aware that he did have a job interview scheduled with Ruby Tuesdays. Ruby Tuesdays at the time that this allegedly happened, and he was already intending to enroll in a local barber school to get his Florida certification to be a barber. So he did want the court to be aware that he was attempting to set down roots here at the time that this all allegedly happened.
And Mr. Martinez, that means a lot to the court. I did see that you're a professional chef and a master barber. I highlighted that. Married, about 5 daughters, and that 4 of them are enrolled in a local school, elementary school. It was unusual the way that paragraph 4 was written as far as the co-defendant, and I'm glad that Mr. Kleins pointed that out to the court. When I look at the first appearance information sheet, it shows 7 failures to appear and 5 violent felonies. Shows other felonies 6, violent misdemeanors 4. Based on that, and also that you've moved to the area, and the allegations against you, respectfully, your motion to reduce bond and modify the bond is denied. So, Mr. Martinez, is he going to appear on January 13th?
He actually has an arraignment date on December 12th, Your Honor.
Okay. Mr. Martinez, I'll see you on December 12th. Thank you.
I'll come see you before then.
Where do we go? There's one case next. Scott.
Thank you.
Your Honor,
Yes, sir.
may I approach?
Yes, sir.
Is that all we have?
So Ken, if you will, if you'll stop the video recording.